Good morning and welcome to our eVisas and Digitalisation webinar. I'm Nick Gore, a partner here at Thomas Solicitors, and I'll be joined by my co-partner, Irfan Ali, who leads our business client work, and Carla Mirallas Martinez, an experienced solicitor on our team with significant experience and expertise in the EUSS route, amongst others. The digitalisation process of the immigration system has been quietly ongoing in the background for some years now, and amounts to one of the biggest practical changes to the UK's immigration system. And we are very happy to speak about this today. This webinar will be made available as a recording straight afterwards, and it's accessed through the same link that you used to join us. There is a question and answer function available in this chat, and we'll have a Q&A session at the end of the session also. First of all, we'll just go through the business immigration services we provide. I'll take myself off the camera so we can look at the slides. We provide advice on right to work processes and civil penalty and other enforcement action and defence work. As you will see, we'll be looking at the right to work process today in the context of digitalisation. We also provide assistance in sponsor licence applications, including skilled workers, sports persons, creative workers, and more. In addition, we can provide assistance in sponsor licence management, and we'll talk about some of the extensive duties that sponsors must comply with, and we can provide advice in relation to these also. And then we can provide on-site or remote immigration compliance reviews and mock interviews where we can pretend to be the Home Office. Our other services include bespoke training and day-to-day legal advice and support, and this is across a variety of different immigration areas. We can also provide assistance in certificate of sponsorship assigning and visa application preparation for workers and their dependents. And again, this is across a number of different sponsored routes. And finally, we can provide advice on other immigration routes and options that may apply. So now we'll move on to the session outline that we'll go through today. So in this session, Carla will cover the basics of immigration control, the digitalisation process, and eVisas. This will form a background of the digitalisation process that we've seen. And also Carla will cover creating a UKVI account and provide some practical tips as to how to go about this. Irfan will then discuss in detail the actions for organisations, including things like the right to work checks and sponsor duties that may apply. Then I will cover the troubleshooting, common issues, and we'll also have an example to go through. And then finally, we'll have a Q&A. Now, without further ado, I'll hand over to Carla.
Hello, good morning, everyone. I'm Carla Mirallas. I'm a solicitor at Carter Thomas. I will now cover the first topic, which is the basics of immigration control. So, individuals without right of abode in the UK require a visa to live and work in the UK. So the most common work visa, as you will know, is the skilled worker visa. Those in the UK are subject to conditions. For example, skilled workers are subject to restrictions on additional work or study that they might wish to undertake. Being a sponsor license holder and a sponsoring migrants is regarded by both the Home Office and the courts as an extremely important role, central to the integrity of the immigration system. The Home Office has placed responsibility firmly on sponsors and will hold them, rather than itself, to account via enforcement action where there is any abuse of the system. It is important to understand those concepts, particularly now with the digitalisation of the UK immigration system. I'm now going to be covering the digitalisation process. In this page, in this slide, you can find the key sources of information relevant to this topic, including some articles that Carter Thomas have published to help applicants to understand what is coming next. In terms of a summary of the changes, so the key date is that by the 1st of January 2025, the Home Office is aiming to have a fully digitalised immigration system. What that means is the physical visa documents, such as biometric residence permits, BRPs, will be replaced by an electronic visa that is going to be called, or is called eVisa. What this requires is that individuals will need to proactively create a UKVI account if they don't already have one. For example, those who have EUSS status may already have one, in order to view the immigration status online. Individuals will need to keep, and this is also very important, will need to keep the UKVI account up to date with the current passport so that they can travel easily going forward. It's important to understand that this is not an automatic process. It requires individuals proactively creating UKVI accounts. As part of the digitalization process, there has also been other changes affecting the entry of visitors in the UK with the introduction of the Electronic Travel Authorization Scheme, the ETA. What that means under the scheme is that all non-British and Irish visitors who are not required to apply for a visa will now need an ETA in order to travel to the UK. This will be implemented widely from January and April 2025. Now, it's important to understand that this is basically a digital permission to travel to the UK. It will apply to EU as well as non-EU nationals. It will cost £10 and it will last for 2 years. I'm now going to be covering the issue of the eVisas. So the eVisas is a key element on the move to the digitalization process of the immigration system. There are different types of immigration documents that exist, and some of them will have access directly to an eVisa. For example, biometric residence cards, BRCs, issued under the EU settlement scheme, biometric residence permits, or frontier worker permits. These type of permits will applicants with those type of permits will be able to create UKVI accounts and have access to an eVisa. However, there are other types of immigration documents that are also quite common. For example, vignettes, a sticker in an applicant's non-UK passport that confirms the right to remain, or a wet ink stamp in a non-UK passport that confirms again the right to remain indefinitely. Those type of documents, physical documents, applicants cannot yet access an eVisa. Now, what do we do with those documents? So what do we do with individuals who have documents that have not yet enables them to access to an eVisa? Again, that includes situations where someone has indefinite leave to remain or enter, and they have, instead of a BRP, they have a vignette sticker in the passport, a wet ink stamp, a form for a fixed visa, or simply don't have or have never been given an immigration document. In those type of cases, what they should do, they must first apply for a BRP. That's going to be done through an application process called No Time Limit, NTL. Through this process, what they will then get is a BRP to show the immigration status. And after they got this BRP, they will then be able to create a UKVI account. Now, early this morning, we have received email correspondence from the Home Office informing that they will stop issuing new BRPs from the 31st of October 2024. What that means is that basically those who have NTL applications and they get resolved before that day, they will still might get a BRP so that they can then use it to create a UKVI account. But those whose applications have not been decided by then, they will simply not receive a BRP, but they will then be given instructions as to how they can now create the UKVI account. Again, it's a quite lengthy process at the moment. It can take up to 6 months for NTLs to be resolved. Now, we're going to talk now about creating a UKVI account and the main 3 steps that are required to do so. So what do applicants need to create an account? First of all, they need to have access to a smartphone, laptop, or other device. They need an identity document. It could be a BRP card or a valid passport. They also need a BRP number or an application number. Normally, applications numbers for the Home Office starts with UAN or GWF. They will also need to introduce their date of birth, the email address, and the mobile phone number. Those are the contact details that they want to link themselves, so the UKVI account with their visa. And importantly as well, they will also need to download and have access to the UK Immigration ID Check app. Now, the 3 steps process to create a UKVI account are the following. First of all, applicants need to first create the UKVI account, and they can do so online following the link provided in the slide. They will need to follow the on-screen instructions, select the option of create an account, fill in some personal details, and then will receive an email confirmation confirming that they have now created a UKVI account. Secondly, They will then use the UK Immigration ID Check app, which the applicant should download it in advance, and follow the on-screen instructions. Through that app, they will take a picture of the ID document and as well a kind of a selfie of their face. Okay, so that will be the verification process. Once the UKVI account has been created and the applicant has confirmed their identity, then the third step will be linking the UKVI account to the eVisa. Okay, so they will need to complete the task list, agree to the declaration and submit, and then they will wait for the email confirmation confirming that the UKVI account have now been linked and that they have access now to the eVisa. Updating details. This is very important because an eVisa will be linked to the chosen identity document that was used in the account creation. Okay, so if the identity document then expires, the person replaces it for a new one, etc., lost it and then applies for a new one, it's very important the applicants remember to update the identity document with the eVisa, okay, to avoid any problems entering the UK, being questioned by border officers, etc. They should also update their other personal details. For example, if the applicants change their phone number, their email address, etc. Updates can be made quite easily via the update your UKVI account link provided in the slide. Is done online. And the service, and this is important for employers, is not available if you are registered on the applicant's account as a helper. So applicants themselves will need to do it. Now I will hand over to my colleague Irfan Ali, who will cover the next section on action for organizations.
Thank you, Carla. Good morning, everyone. So my name's Irfan Ali, and as Nick mentioned at the start, I'm a co-partner here at Thomas Solicitors, and I mainly deal with business work and take the lead on that work stream that we get through on this. So I'm going to now just walk through the actions for organizations, and I'm going to also just touch on right to work checks and also sponsor duties, but I'm only going to be talking about those briefly because we will have a session on right to work checks and sponsor duties later this year. So if we can then, so in terms of the organizations and what they need to be doing, it is important that they are aware of how the digitalization of the immigration system is going to be impacting them and the employees, and they need to be prepared for that change. And I think just having some issues with my slide. If I just need to try and move on to the next page. So yes, I mean, so Carla's just summarized in terms of some of the upcoming changes, which is more directed towards the individuals. The Home Office are also working on other changes which are going to be more direct to the sponsors, and this is doing an overhaul of the sponsor management system. So this is the portal that's used for managing sponsorship generally. So we expect over the next year or so, some people will some people get access to this new system, and they're going to be trialing it out, and then once they've gone through that trial process, they will then be releasing that to the wider group of sponsors. So that's something else that the Home Office are working on, something to just keep an eye out in terms of going forward. So as part of the immigration development system that is digital by default, as Carla mentioned, the physical documents are going to be phased out by the end of the year, and the Home Office have confirmed that they're going to stop issuing the BRP cards from 31st of December 31st of October, 2024. Now, all BRP cards have a standard expiry date of 31st December 2024. And aside from visas expiring before this date, typically the individual will have permission to stay in the UK that ends after that date. Now, the holder's rights and entitlements are unaffected as the date refers to the expiry of the document only and not to the holder's immigration status. Now, we would recommend that organisations are in contact with any employees who have a visa to ensure that they're aware of the need to set up a UKVI account and to link the eVisas to this to view their status. So this is not just applicable to sponsored workers, this is also to any non-sponsored workers. So for instance, if you have any individuals who are on a partner visa or a dependent visa or a student visa, it's also important to check in with those individuals as well, just to make sure that they are aware of the actions that they need to take. And it is important for organizations to ensure that they hold accurate records of the employees with time limited permission or indefinite leave to remain, and that the information recorded reflects the expiry date of the employee's permission rather than the date the BRP card expires. Now, we've conducted a number of compliance reviews recently, and one of the areas that we look at is records relating to migrants, so both sponsored and non-sponsored individuals. Now, this is often an area that requires improvement, and we found in a number of cases where correct data has not been recorded or where there's been a lot of incomplete information. This is particularly the case where there have been a number of changes within the organisation or where those responsible for managing this process leave and a proper handover has not happened. The transition to the digital only system is an opportunity for organisations to undertake an audit of the records and ensure that any records reflect the actual expiry date of the workers and not the BRP expiry date itself. This is also a very good opportunity to thoroughly review your right to work procedures along with any compliance with applicable sponsor duties. Here we've got a link. Now the Home Office have been working on sending out communications to employers and sponsors, and they basically provided a template email that organisation can use and adapt when reaching out to workers. And it is very useful to have a look at that link, see what the Home Office have put together, and if they want to, if you want to use that as a means to start reaching out to workers, that's a really good way of doing that. The other thing as well that organisations should be doing is following up with the employee to check that they've UKVI account and have access to their eVisas, particularly for those who are required to travel frequently, to ensure that there's no issues with them re-entering the UK. So as we starting to draw closer to Christmas, a lot of people will be booking their travels over the Christmas period to see family. So I think it's important to ensure that everything's all in order. When they do travel, for them to coming back into the UK, that they're not going to experience any issues on that front. So now just to look at just a few issues with right to works and where this all slots in, and this is just looking at it from the perspective of sponsor duties. Now, employers wishing to protect themselves against sanctions under the Prevention of Illegal Working legislation must comply with the Home Office's requirements, and employers that have a sponsor license have a positive duty to check their staff have the right to work, and this is set out in the sponsor guidance, which states that you must check that any worker you wish to employ has permission to enter or stay in the UK and can do the work in question before working for you. Appendix D of the Home Office guidance also lists the document that must be retained by a sponsor, and this includes evidence of the worker's right to work. So an employer will maintain a statutory excuse if the initial check were undertaken in line with the guidance that applied at the time of the check. And again, when we often when we do the compliance reviews, we often come across a number of issues where partial right to work checks have been done or not at all. And it is important to ensure that compliant right to work checks are carried out at all times and in line with the current guidance. And we will be expecting the Home Office to update the guidance on right to work checks. Me and Nick were speaking at a conference last week and on just sponsorship generally, and the Home Office were present at that conference. And one of the areas that the Home Office said is a very particular hot topic for them is the issue of right to work. Now, anyone expecting a compliance visit from the Home Office, right to work is certainly going to be an area that the Home Office will be looking at in terms of wanting to do a sample check to see if right to work checks have been done, have a look at the processes, and if they suspect that someone may not quite fully understand the process, they will dig deeper, trying to get a full understanding of that, just to make sure that if they have to see what the processes is, if there are any failures. So that is an area that everyone should be very familiar with, and they should be hot on that and always coming back and just doing some checks on the systems and processes just to make sure that everyone's clear in terms of what that process is. Now, in terms of the statutory excuse that I mentioned, this is essentially like a type of insurance almost, but in order to benefit from it, you must carry out the right to work check. So, for example, if it transpires that an individual does not have a right to work in the UK, for instance, they provided a fake passport, the employer will be protected from a penalty of up to £60,000 per individual. So with the introduction of eVisas, this in itself does not trigger a requirement for employers to conduct further right to work checks on the existing employees, but it may need to be undertaken in certain situations. Now, many of you will be aware that as of 6th of April 2022, biometric residence permit cards, biometric residence cards and frontier work permit holders must evidence their right to work using the online service. So this is where they have the share code, and then they share that with you, and then you go onto the website, and then you basically input that code, and then you can verify the information. So employers are no longer able to accept or check a physical BRP or BRC or frontier worker permit as valid proof of work, although we have seen a number of cases where people are still looking at those physical documents as a right to work, but that's no longer acceptable. So so where a online check was carried out, there should not be any issue in relation to the expiry date of the BRP in this sort of scenario, because the employer will have a record of the actual visa expiry date through the online check. So no further right to work check will be needed in this instance. Now, before 6th of April 2022, employers had the choice of whether to do an online right to work check or an original document manual check. Now, if a manual check was carried out on a BRP card expiring on the 31st of December 2024, likelihood is that the employer may not know when the visa itself actually expires. Now, where the employer has carried out such a check and recorded 31st December 2024 as a right to work check as the expiry date, the Home Office guidance states that a follow-up check will be required. So this is where they have to do an online right to work check, and this again must be done before the end of the year. So even if an employer has seen the UKVI approval letter, which shows that the visa, which basically confirms the visa that they've got and the expiry date, an online check must still be carried out in order to benefit from the statutory excuse beyond 31st of December 2024 in those sorts of situations. Now, just moving on to sponsor duties, and this is just looking at it as a wider framework and basically where this all slots in. And sponsor license holders, as many of you will be aware, there is a duty to comply with the sponsor duties, and there's a number of responsibilities that also must be met. And the consequences of failing to comply with the duties can be quite serious, including the license being downgraded or revoked and permission for existing sponsored workers being curtailed. Now, just on the slide here, you can see that we've just set out some data on compliance action figures over the last few years, and this just provides a snapshot of the landscape before COVID up until to date. And obviously, 2020, 2021, that was when things were, we had COVID, we had Brexit. Obviously, they weren't, the Home Office weren't conducting many compliance checks. And then since 2022, there's been a gradual increase in terms of license being suspended and then license being revoked. And then in 2023, the total number of suspensions were 569, and then the total number of revocations were 337. Now, just to put this in context, so from Q2, from this year alone, there's been a total of 833 suspensions and 709 revocations. So it shows that the Home Office, there's been a massive spike in compliance action by the Home Office. And the Home Office, I mean, these are based on the published figures from the Home Office. But when we were at the conference, the Home Office did say that as of middle of September, they've actually revoked around about 1,300 sponsor licenses. So I think this is certainly an area that the Home Office are looking at a lot more closely. So it is important for people to undertake, do a mock audit of the processes and systems, just to make sure that, in the event that the Home Office do undertake a compliance visit, that they are aware of what to expect and they don't get caught out by any issues on that front. Now, here we've got basically what I mentioned just previously in terms of the sponsor guidance. So the guidance is updated on a regular and frequent basis, and it is important to ensure that people are reviewing this on a regular basis. And where there's been any changes, so for instance, with right to work checks, so like I mentioned previously, the check has to be conducted in line with the guidance at the time. And there's been some various changes over the years. So it's always good to keep a record. So if you have policies in place which is in line with the current guidance, it's always good to keep a copy of the guidance as well, so as a reference point. And then when that changes, the policy should also change and should also keep a copy of the guidance. So if any event the Home Office ask any queries or questions related to that, you've got something to look at as a point of reference. And here, the relevant duties here, Appendix D, in terms of keeping documents. This gets updated on a regular basis, and it's important to ensure that any record keeping and reporting duties are appropriate to the size of the organization, and it has to be effective in terms of the documents that they retain on that. And doesn't it, I mean, in terms of retained documents, you don't have to have fancy software or anything like that. As long as it complies with what the Home Office want, and this is set out in Appendix D, then that should be fine for the purposes of being able to meet that requirement. Monitoring expiry dates, this again falls into, keeping track of when visas expire. This is extremely, this is one of the areas again that the Home Office really look at in terms of checking to see how organizations are keeping track of the employees who are subject to immigration control. And businesses need to have an effective HR system in place to identify who has a visa permission, and that the efficient processes are in place regarding compliance and right to work checks, and that any records are clear and effectively monitored. And a lot of the times as well, what we tend to find is that they will be published. A lot of organizations have published policies and procedures in place in terms of monitoring expiry dates. But when we do a check on that, we often find that a lot of the times, or there's been a number of instances where that process hasn't been followed. So it is important to make sure that if you have any policies in place, it is being followed. And if any changes do need to be made, it is, that those are then made, in line with the current guidance. Again, reporting changes, right to work checks, all of this, there should be systems in place where you are checking in frequently with your workers, making sure that if there are any changes that need to be reported, this filters through to the relevant individuals. There may be series of managers in between, in terms of from those who manage the license and the actual worker itself. So there needs to be like a chain in terms of, okay, for instance, if there's been a salary decrease for a sponsored worker, that is something that needs to be reported, and that report has to be done within 10 working days. So it needs to be, you need to have measures in place that allows the appropriate level 1 user to be notified of that change, so that they can then carry out and then make the report accordingly on that. So this is basically just something that we just an area that we touch on, but we will be going through this in a little bit more detail with our upcoming webinars, which will provide further details in our legal updates. I'm going to now hand you over to Nick, who will now just take us through the next section.
Thank you, Irfan. That was very informative, which is great. So now we're just going to go through some troubleshooting and common issues that we see, as well as an example to give some colour to this interesting area. So some individuals who have accessed their eVisa are finding the information is incorrect. So classically, incorrect visa expiry dates, and previously there was an issue of an individual's previous permission being visible rather than their current one. This is obviously an area that is still being developed. There are some teething problems from the Home Office. So the current advice is to call the Home Office Digital Status Helpline, and we've provided the link there. Or for education institutions, there is a specific error report form, and again, the link is available on the slide as well. There can also be issues linking eVisas following the grant of permission. So as Carla was saying, you set up a UKVI account, and once you've done that, you wait for the confirmation from the Home Office that the eVisa has been linked to the account. Ideally, that should be instantaneous, but again, this is a developing area, and although it can take a few days, in some cases it's taking up to a month or a month and a half. We do understand that this process is being developed, and that time frame should come down as well. And we'll of course make sure that any major developments are kept up to date on our website as well. Some further common problems are whether there should be separate UKVI accounts for children. It's now been confirmed that a parent or guardian or responsible adult will need to create a separate UKVI account for the child. They'll also need to manage it, which means keep it up to date with the various documents if they change, or various details if they change. As Carla was saying, things like an email address, phone number, or a physical address needs to be changed. It will have to be a separate account per child, and that account can be handed over to the child when they become an adult or responsible, just by simply changing the contact details. Individuals are also advised to update their UKVI accounts to their passports after a new grant of permission. However, some passports do not have biometric chips. Individuals can, and appreciate this is slightly confusing, can use their previous BRPs in these circumstances. So you can tell whether a passport has a biometric chip by the symbol on the front. It has a sort of small rectangle. Most passports do these days, but not all of them. Again, it's an ongoing area that's being developed. So in these circumstances, individuals can rely on their BRPs, even though they do have an expiry date. This is an area we're familiar with from the EUSS process, where similarly people are asked to retain their old BRPs in those circumstances. The reason for doing so is because those BRPs do have the biometric chips. So essentially, you're just relying on the document itself that links who you are to your eVisa account, rather than what it says on the document. Obviously, once you have the eVisa account, you can log in, you can review the details, and then that can be clear for both yourself and in any right to work checks, right to rent checks, and indeed on entry. And linked to that, returning expired BRPs. It's now been confirmed BRP holders should keep their expired BRPs. There used to be a line in decision emails about if a BRP is not returned, you would be fined. That line is now being removed, which is piece of helpful clarity that's been provided to us. So now we're going to go through a case study just to make sure we're all very clear on this process. So employee X has permission as a skilled worker and their BRP valid until November 2024. B extended his skilled worker permission with his current employer. He has an overseas conference in January that he wishes to attend. So how will the eVisa system affect him? Employee X will need to apply for his extension before his current permission expires, or he would be without permission. Once he submits his application, he will hold 3C leave. That means his current permission will continue past the expiry date on his BRP until a new decision is made, and he will continue to hold the right to work and rent in the UK. The application process should require him to use an app that will scan his face and his BRP, the same process that Carla was talking about earlier, and he can do that rather than attend a physical biometric appointment. He may wish to consider using a priority service to obtain his new permission in time for travelling in January, as he shouldn't leave the UK whilst the application is pending. We'll continue with this example on the next slide. The Home Office have confirmed that BRPs will not be issued from October 2024. Therefore, if it's successful, he will receive a decision email confirming his grant of permission. He will likely already have a UKVI account, which he can log into to access his eVisa. Of course, he may have to wait until he can access his eVisa because of that delay. We're talking about that month to a month and a half. It is recommended he still travels with his expired BRP until the end of the year and until his eVisa is viewable, just to ensure that he's got the security. And in this scenario, his employer would need to do a new right to work check simply because he's got a new grant of permission. Great. With that, we'll look at some of the questions that have been coming in. We've had some really great questions, and do keep them coming in, and we'll get through as many as we can. So first of all, question for you, Carla. What personal details do I need to keep up to date on the eVisa UKVI system?
Thank you, Nick. Yeah, so it will be the usual contact details. So the email or the phone number. If those change, it's very important to update the UKVI account. Of course, the BRP or the passport, which is linked to the eVisa, if those documents then get renewed, etc., especially the passport. Address, I believe there's also a section on the personal address of the applicant. So again, if someone changes address, they may need to also update it. There's other details that are unlikely to be changed, like date of birth or full name. But again, if the full name of the person changed for whatever reason after marriage, etc., those details will also need to be updated. And that's basically to secure that all the information recorded in the Home Office system makes sense, matches. So the passport, the traveling document matches the eVisa, so that there's no issues then in terms of traveling in and out of the country, or with any other issues like also accessing services or right to work check. So everything has to kind of make sense.
Perfect. Thanks so much, Carla. Then one for you, Irfan, one that you covered in your talk, but again, it's helpful to have clarity. Do employers have to repeat right to work checks for anyone really? But in this question, it's for indefinite leave to remain holders whose initial right to work check was conducted manually on the basis of their BRP card expiring on 31st of December 2024.
Thanks, Nick. So yeah, so generally, where someone has limited permission to remain, they basically do the right to work check, record when that visa expires, and then there is a need to carry out further right to work checks before that permission expires, where they've done an initial check and the individual holds indefinite leave to remain. Further right to work checks won't be needed in that particular instance, because that should have indefinitely to remain is basically someone who's no longer subject to immigration control.
Perfect. Thank you so much. One of the questions we have was, how does it work for kids? Can I have their eVisas under my UKVI account, or is it mandatory one account for each eVisa? So it is one account for each eVisa. So parents or responsible adults can set up an account for their children, and they can put their contact details in rather than their children's contact details to help manage their account as well, for the things Carla was saying about any changes to address and things like that. When the child is old enough, you can hand over responsibility for that account by simply changing those contact details there. So I hope that answers that question also. So one of the questions we've also had is, do you have any practical tips to set up a UKVI account? I know many people have had issues with the scanning in particular. So one aspect we've seen is when you come to set up a UKVI account, you have to do the process Carla was talking about, which includes taking a selfie and also scanning the BRP. In that scenario, the app itself works as almost like a passport scanner. So it's very useful to think of it in that scenario, because then you think of how best do you work a passport scanner, and that includes things like taking a case off a phone. That's helpful. Hovering the phone above the BRP or passport to help do that scan, and also taking a picture or a selfie with a blank space behind you, almost as you would with a passport photo as well. The practical guidance is quite useful for these sorts of aspects as well. I don't know if you've got any other practical tips you're able to offer there, Carla, in relation to setting up the UKVI account or the scanning of documents or taking of pictures at all?
No, I think you covered them. Like, I think the white background when taking the selfie is important, because if there's many objects behind, the app might not recognize the face properly. And definitely with the scanning the passport, we have encountered that, or the BRP, we have encountered that. Yeah, if you don't remove the case, or sometimes for passports that are quite old, where the chip might be older than newer passports, they're also more tricky to access the biometric information on the passport or BRP. So you need to keep trying. And I think if there is any technical issues where a person cannot use correctly the ID document checkup, I think there is a phone number as well, an assistance number where you can talk to UKVI to explain them that you cannot do that. I believe so.
Yes, yeah, there is another question. Is there any guidance to help set up the account? Yes, there is various guidance, and as you say, Carla, there is a resolution center and a sort of an e-chat option as well, and that's quite useful to help set up the account, which is great. A question for you, Irfan. As you mentioned, we're going to have a right to work webinar later in the autumn as well, and you covered this in detail in your slides, but it's useful to just talk about it again. So first of all, how do you do a right to work check with the new system? If you know, again, because we're going to do a separate webinar on this, if you want to provide a summary, that'd be great. And we've also had a separate question saying, what is a statutory excuse? If you want to answer both of those together.
Yeah, no, thanks, Nick. So yeah, so now with the obviously with as we've been discussing with the eVisas UKVI account, so when a individual receives permission and right to work check needs to be carried out, the individual basically can log on to the government website and they log on to the app, and they can then generate a code. And they normally there's different. They can request a code, one for work, one for rent, and they just need to make sure that if it's for work one, they select the correct option to get the code for the work, and then they will get that share code to the employer, who will then basically need to log on to the government website where they input the information, and they'll just need some details regarding the worker, for instance, their date of birth, and then they'll basically need to put in their information in terms of, and I think this is another point as well, where we often find where we do tend to see some issues with, is when the employer is carrying out right to work checks, do make sure that they put the employer's detail on as that the organization carrying out the right to work checks. This is just to ensure that if at a later stage the Home Office do some inspections and they see, because normally that report will show you which organization carried out the check. So I think that's always good to basically do that check, and then you get access to the so once you input the information, you go on to the next stage, and then you basically will be able to view all the information. And that's where employers need to make sure that they check the information on there, record any relevant key dates. They may want to take a screenshot, print it off on file, and so they got that, so to make sure that everything's all matches. And the other thing as well that the guidance says is that the employer needs to just do a quick check to make sure that the picture on the right to work check matches the individual. So it is important that employers go through that process of fully making sure that they actually log onto the system, view all the information, because we have seen instances where they've just got the share code and that was it. Generating a share code in itself isn't the right to work. You need to actually log on to the system and make sure that the all that information is visible and anything is recorded on that front. In terms of statutory excuse, so this is basically what I mentioned previously. So generally, all employers have an obligation in terms of making sure that they're not employing anyone illegally. Although there's no positive obligation for those who don't have a sponsor license, but if the Home Office were to ever do a raid of some sort, and they figure out that they've got individuals who are working for them and they don't have the right to work, this is where they may be subject to civil penalties, and that can be up to £60,000 per individual. And carrying out the right to work checks is basically allows you to have that insurance that I mentioned earlier. So if the organization carried out the right to work checks and they followed the process, everything was compliant, and they were satisfied that this individual has right to work, then they can retain that on file. And then it turns out, for whatever reason, in the example that I mentioned about, this individual may have given a fake passport, and actually the individual doesn't have a right to work, that's where you can then rely on that statutory excuse in terms of a right to work check was carried out, we will satisfy this met requirement, so then you won't be subject to that civil penalty. And I think the other thing to mention here as well is in terms of when organizations are looking at right to work checks, this should be done across the board and for all employees, to avoid any sort of claims of discrimination or anything like that. And that way, then basically you have accurate records of who your employers are, and so who your employees are, and anyone who is subject to immigration control. I think one of the other things as well is to make sure, particularly for students, because yes, some of them have, obviously they may be studying, but some of them do have the right to work. And when you do the right to work check, it will detail any restrictions on their employment, and it is important to make sure that they make a note of that. And for instance, some students may just be able to work 10 hours or 20 hours for as an instance. So you just need to be able to show that they're not falling in breach of those conditions on that front.
Great, thank you, Irfan. And for you, Carla, we've had a question. For someone with ILR on a vignette from 20 years ago, do they have to do anything?
Yes, so that links to what we were discussing earlier about the NTL application. So at the moment, the advice that what the Home Office have published in the guidance is that those who have a ILR stamp in the passport, or an old vignette, or simply they know they have ILR but they don't have document to show the immigration status in the UK, in those kind of scenarios, they cannot yet access an eVisa. So the advice at the moment is for them to make an application, a no time limit application, for them to be able to access that eVisa. Now, as we discussed, if this application it takes a long time, it can take up to 6 months, but if it gets resolved before the 31st of October 24, the person then will be issued a BRP that then they can use to create the UKVI account. If not, in the most likely scenario that they is not resolved by the 31st of October 2024, when the NTL application has been decided, they will then be given instructions as to how to create a UKVI account and link it to the eVisa. So at the moment, the Home Office expects some proaction, some activity happening from those who don't have PRPs and otherwise have indefinite to remain through the NTL process. It's a free application. It's quite lengthy actually to complete. We can provide assistance, of course, if required. And as I said, like, it takes a while. In the meantime, whilst the application is being processed, because of how long it can take, the Home Office is also advising those who have those wet ink stamps or vignettes showing the indefinite to remain in the old passports to continue traveling, if they have to do so, in and out of the UK with the current valid passport, as well as with the old passport showing the old stamp. Okay, so it's not that they, after the NTL application, they cannot travel overseas. They still can during that kind of transition period while the application is pending.
Perfect, thank you, Carla. We've had a few questions about children, about when they should be able to manage their own accounts. It's an interesting question because the Home Office have been quite vague on this. They simply say when the child is able to manage their UK account themselves, or where they reach 18 years of age, the child's account can be transferred to them. So there's a bit of discretion there. Obviously, it's quite a serious thing to transfer that to a child, so you'd have to make a decision there about when to transfer of course, when they're 18, they can have responsibility of their own account as well. So probably the final one for you, Irfan, and it's sort of a two-part question. Is it a sponsor duty to have workers' expiry dates recorded? And finally, can you help us review our sponsor duties?
Thanks, Jake. So as part of the sponsor duties, you need to be monitoring individuals' immigration. So effectively, you should not be employing anyone who doesn't have the right to work, and that's, that is one of the fundamental principles of sponsorship, is that, because a lot of trust is placed on sponsors, and Home Office are effectively, passing on some of their responsibilities to organisations. So as part of that, they need to make sure that the right to work checks are being carried out, and that any individual who is working for them has the right to work to be able to do that. And that's where we discuss in terms of keeping records of anyone who needs to have the anyone who has time limit permission, and to carry out follow-up checks on that. And we can certainly assist organizations in terms of managing these sponsor duties. And a good way that what we tend to do when we have a look at this is our compliance reviews. This is essentially, we normally tend to do this remotely, but we can do in person if you want to. But this process allows us to ask some questions in terms of organisation policies, processes, systems, etc. We'll do sample checks on right to work checks, sample checks on workers' documents. We'll do, we'll basically run through some of the Appendix D things to see what information is being retained on file. We'll just basically, there'll be some various questions in terms of just trying to understand if they're aware of these sponsor duties, in terms of when does a report need to be made relating to the organization, when the report needs to be made relating to the worker. And we'll try and have a look to see whether or not, if there has been any things to identify, if there have been anything that suggests that a report should have been made. So all of this is something that we can cover off as part of our compliance reviews that we do for our clients. And we would recommend that these reviews are done at least once a year, because it's a good opportunity, and probably more so if there's been a significant change within the organization, people move on, because what we often find as well is that the SMS for some reason doesn't get updated for whatever reason, because who was managing it left and didn't hand over anything. And so those kind of, it helps the organization to pick out those points, and you rather work on any you'd rather have a look at your systems, work on what needs to be improved, because the last thing you want is for the Home Office to basically do an inspection and they find all these issues. So if it just allows you to basically look at your systems and then just work on any weaknesses and address them going forward.
Perfect. Thanks so much, Irfan. Well, thank you everyone for joining us today. It's been a rollercoaster ride through the eVisa and digitalisation system, which has been great. As Irfan mentioned, we've got upcoming webinars covering various topics, including right to work checks and sponsor license duties as well. We will be keeping everyone up to date on both any Home Office developments of significance, as well as any eVisa digitalisation updates of significance through our website, and you can sign up to legal updates there as well. And otherwise, you've got our contact details here in the slides. If you do have any questions you'd like to ask us, please feel free to get in touch. So all that's left for me to say is thank you very much for joining us, and I hope you have a lovely day today. Bye-bye.